Okay, we're now going to swear in the jury. Ladies and gentlemen, please rise. Ms. Bryson will administer the oath.
Do you swear and or affirm that you will well and truly try the issue joined in this indictment between the United States of America and Larry Bass, and that you will render a true verdict according to the evidence to have been done and do you affirm?
All right, thank you, ladies and gentlemen. Please be seated. Okay, all right. I would like to start the trial this morning and go to 12:30. You have so we'll have. I'm going to give the jury some opening remarks, and then you'll do your opening, and then can you call your and then we'll Mr. Kaufman has a work, but we may get to your first witness. Will you be ready for that, Mr. Whitehead?
Yes, Your Honor.
All right. Okay. All right, ladies and gentlemen. Here's the procedure we're going to follow. At this time, I'm going to give you some general instructions. Really, they don't have anything to do with the case itself, but just how a trial is conducted and how you should conduct yourselves as jurors. That won't take more than 10 minutes. Then Mr. Whitehead, as the prosecutor, will give you his opening address, which is really like a roadmap of what he intends to prove. It's not a closing argument. It's really just an opening address so you understand what the government's position will be. Then Mr. Kaufman, as attorney for the defendant, he can then give you his opening then, or he can wait and give you his opening after the government rests its case. And then we'll start with the evidence. And I hope to get, and we'll adjourn for lunch somewhere around 12:30. We may take a little longer than an hour today because there's a judge's meeting that I have to go to. Usually we start court at 9 o'clock in the morning and we go until 4:30. And we take about an hour off for lunch, and we take a mid-morning break and a mid-afternoon break. And when we break for lunch, Ms. Bryson will talk to you in the jury room. She'll give you a little jury badges and find out if you have any special requirements in terms of transportation, either to or from court, that we need to know about. Now, a trial proceeds, as I said, with the attorney for the government giving you an opening address, and then if the defense lawyer wants to do the same, he can, and then you call the witnesses. Now, the testimony of a witness is usually four parts to it. First part is what we call the direct evidence. That's when the party that called the witness asks the witnesses questions. And then we have what cross-examination, where the other attorney cross-examines the witness, and then the party calling the witness is allowed redirect or something that came up on cross, and the other attorney is allowed recross, which would bring up, ask questions about what happened on redirect. And then the witnesses step down. Now, the testimony of witnesses is very important because you, the jury, are the finders of the fact. You're the jury, decide what the facts are, and you render the verdict. My job is to supervise the trial and to give you the instructions on the law. But the fact finding is your business and your business alone. The most important thing, in most cases, for a jury is to determine the credibility of witnesses. Now, credibility is a fancy word for believability. And credibility is not the same necessarily as somebody telling the truth or somebody lying. Obviously, if you include that somebody is lying, then you're not going to find them credible. But you may have several witnesses testify about the same thing. You may believe they're all trying to tell you the truth, but that some are more credible than others. Maybe somebody has a better memory. Maybe somebody is more articulate. Maybe somebody just impresses you as somebody that knows what's going on, whereas other witnesses who testify about the same incident don't impress you as much, and therefore they're not as credible. So credibility or believability is a very broad concept. And in order to gauge credibility, you have to pay close attention to the witnesses and how they testify. And you want to pay attention to the answer, to the question rather, and the answer, as well as the answer. Is the witness responsive? Does the witness listen to the question? Does the witness answer the question? And things like that. And as the witnesses are called one by one, you need to listen carefully to them, because when you deliberate, then you're going to have to discuss among yourselves who was credible and who was the most credible and where you find the facts. Now, as I said very briefly before, the government has the burden of proving the defendant guilty beyond a reasonable doubt. And the defendant is presumed innocent. So we start out with the defendant is presumed innocent on a clean slate, and the purpose of the government calling witnesses is to try to persuade you beyond a reasonable doubt that the defendant is guilty of the crimes charged. And I'll have more to say about that at the end of the trial. After the government calls all its witnesses, then the government will rest, and then the defendant may call witnesses. Now, the defendant doesn't have to call any witnesses, and the defendant doesn't have to testify himself, because the burden is always on the government to prove the defendant guilty beyond a reasonable doubt. And you may not make any inferences or conclusions if the defendant doesn't call any witnesses or doesn't testify himself, because the defendant has no burden whatsoever. The defendant is presumed innocent. Now, during the case, you will probably hear one party or the other, one lawyer or the other object. And objections are addressed to me, not to you. So I have to rule on objections, and objections are based on what a lawyer perceives may be a question that's improper or should be rephrased or something like that. These objections take place in open court, but as I said, you should not really pay any attention to them. You should not hold it against one lawyer or the other if they make objections. That's their job, to make objections, because I have to be guided by the rules of evidence, and a lawyer has to object so I can rule if they think testimony is being improperly admitted. Now, in this case, there will also be some exhibits, and there will also be some audio tapes. And I'll give you instructions about those as the case goes along. But assuming they're admitted, they'll become part of the evidence, and you will consider them when you deliberate. There may also be some expert testimony, and I'll tell you about that. And there may also be testimony from an individual who will testify that he was engaged in some of the criminal conduct that the government accuses Mr. Bass of. And you'll have some instructions about that as well. The other thing that's very important is that you decide this case based only on the evidence that takes place here in the courtroom and the instructions of law. It's very important that you're not trying to do any research of this case otherwise, or go on the internet and try and get information about anybody or about anything, or about, you heard there's going to be some testimony about drugs. You may not go on the internet tonight at home and find out about drugs or find out about criminal cases or anything involved in that. You must not do that. You must decide the case based solely and exclusively on what takes place here in the courtroom. And the other thing that I'll constantly say to you is not to discuss the case with each other until the case is over and you begin your deliberations. So that means when we take recesses, we break for lunch, you go home a day, don't talk with each other about the case. You talk about the Olympics, talk about shopping, talk about the weather, things like that, your families, whatever you want to do, but don't talk about the case. Save that until you're ready to deliberate. And it's very important because we can only call one witness at a time. And one of you may have a positive reaction to a witness, and another of you may have an adverse reaction to it. And you keep those thoughts to yourself, because if you start telling other jurors how you think, that's not fair to anybody, or yourself, because you want to wait till the entire case is over, all the witnesses have been called, and then you size up the case, you size up the facts, and you use my legal instructions to help you reach a verdict. So just talk about other things. Don't talk about the case in any way, shape, or form while we're deliberating. Now, it's also very important that you hear. If any of you cannot hear what a witness says or have to hear the question, then raise your hand, and we'll immediately notice a problem. Same thing if any of you need a break. We take a break, usually a mid-morning break and mid-afternoon break, but if something comes up, you need a break, just raise your hand, I'll find out what the problem was, and if necessary, we'll take a break right at that time, because we want you all to be comfortable. As I said, you want to bring in a bottle of water, a bottle of soda, anything like that, that's perfectly okay. Okay, so those are the preliminary instructions that I told you I would give. I think I've covered the things I want to at this point, and we're now going to have Mr. Whitehead's opening address.